Okay, everybody, we are right at 2 o'clock, so this is a great time for us to begin this panel. You can tell I'm obviously not going to be sitting up here. I'm just here temporarily because this is the heavy duty panel. So I'm going to be sitting in there taking notes. This is our panel that our three panelists got together, and this was something we talked about, that not every judge is like our judge sitting here on this panel, Judge Ryan T. Holte, who has an extensive tech background. As a matter of fact, Judge Holte, what is your undergraduate degree in your science reason?
Yeah, I'll turn that on. Engineering, yeah.
Yeah. And you've got more than one tech degree.
No, just one.
Just one?
Yeah.
Okay.
But more than one patent.
More than one patent.
That's what it is. How many patents do you have?
5 patents now, I believe. Yeah, one application is pending.
I was going to say, and counting, right?
Yes, and counting.
Yeah.
Are you drafting it yourself?
No, I have no activity. Silent partner.
Well, as you can see, we all readily understand that to appear before PTAB or the prosecutor patent, you have the expectation that obviously the prosecuting attorney is going to have a tech background. These issues then end up before judges, but not every judge has a tech background. So we thought it would be interesting to put this panel together in which, because many of you obviously are going to be appearing before judges, and the best thing to do, as you heard from some of the judges earlier this morning, the judge is relying on you to educate them, to help them, to assist them. And the better that you do that, the better the ultimate outcome for everyone. So we have with us today, in addition to the Honorable Ryan T. Holte, we also have with us Ulysses Williams III, who is a senior counsel for eComm patents at Walmart. And I was remiss in not pointing out that Judge Holte is on the United States Court of Federal Claims. And before I guess, well, I'll just do that and then I'll ask Judge Holte a question. And we also have with us Professor Adam Mossoff, who is currently on the faculty at the Antonin Scalia Law School at George Mason University. So we have 3 patent experts here on this panel. And Judge Holte, you and I, we were talking about this. What was your capacity in which you first attended this conference?
Yeah, so I was trying to think if I first attended this conference as a student or a law clerk, but it was either during law school or right after law school, and then went on to attend it as a practicing attorney, and then also as a law professor speaking, and then now it's a real honor to be able to serve on this panel as a judge.
What a record, right?
And I'll just say much of all of that career progression is in particularly due to Professor Matima and Professor Mossoff, who spent hours with me mentoring and building up the relationships that this conference is such a seed for. So thank you on the record now, Professor Matima, for all of your wonderful friendship and mentorship, as well as you, Professor Mossoff.
Thank you. It is such a pleasure and honor to have you here. And so without me taking up any more time, gentlemen, I turn it over to you.
I'm just going to say it's going to be difficult coming in and speaking in after you, Judge, after that commentary.
Well, thank you, Professor Matima, and thank you all for coming to our panel today. As you heard, I'm Adam Mossoff, professor at George Mason University, Antonin Scalia Law School, and I'm really honored to be moderating this fantastic discussion with Judge Holte. And how would you like to be referred to, Ulysses?
Ulysses.
Fine, yeah. Is there an honorable or anything in your background? Yes. And with Ulysses Williams, who is Chief Patent Counsel?
No, just Patent Counsel.
Patent Counsel at Walmart. I don't believe in going at length about backgrounds and accolades because there's a wonderful thing called the internet with Google. So you can find out all of their incredible achievements and accolades and everything of that sort that they've had. But we were going to be talking today about how you talk to a judge, particularly a trial court judge, who may not know patent. And of course, this intertwines very closely with also who may not know science and technology. And as Professor Matima rightly said, you may not be as lucky enough to have Judge Holte as your trial court judge, who has a science and technology background, actually hasn't just studied patent law, but actually and taught patent law. He was a patent law professor at the University of Akron before becoming a judge, but that actually has patents himself. So he didn't just study it and teach it; he actually practiced it and did it. And then Ulysses, who practices it in the real world on behalf of clients. A very important and significant client, one that I'm sure we have all benefited from and used in our lives many times over in terms of the creation of innovation and the deployment of that innovation in the innovation economy. So we're going to keep this very light and informal. So we're just going to do very brief opening remarks and framing remarks. I'll ask them some follow-up questions, but please feel free as we're talking, if you have a question, to raise your hand, and the moment there's a break, I'll call on you. So we're not going to wait to the very end to say, are there questions? For those who are watching this online, please just type your question in the webinar chat. I'm tracking that, and I'll make sure that we also address that question once it appears and we have a natural break in the discussion. So without much further ado, I'm going to turn it over to Judge Holte. We'll talk for a few moments, and then Ulysses will talk for a few minutes, and then we'll start it back and forth between ourselves and with you. Judge Holte, take us away.
Yep. Thank you, Adam. So, and I would like to note at the onset that, at least for my personal understanding, I would love to have a couple minutes at the end for you to perhaps share some commentary on a related subject, which is how to teach a trial judge to understand patent law, perhaps how to teach administrative bodies or Congress how to understand patent law from the extensive testimony and conversations that you have had, especially recently, which just fascinates me and I have no experience with, other than my time with the Judiciary Committee that I would certainly care not to remember. But the notes that I would just like to share as opening comments are, I think, to know your audience. So the topic that we have is how to help the trial court judge understand patent law. And I think the reality of it is how to help your trial court judge understand patent law. So just by way of example, if you're in the Western District of Texas in Waco, your trial court judge probably has great familiarity with patent law and has strong views and a way of doing things. Conversely, if you happen to be in a district court in Indiana, with the exception of perhaps one former patent lawyer who I know is on the district court there and is a good friend, you might have to spend a majority of the time at especially the beginning of a case, the initial case management conference, or as you proceed for discovery issues or claim construction, in order to help the judge understand what the procedural role is of each step in the case and what the importance is of the procedural step that you're about to embark upon. And probably with that, using those lessons as an advocate for your client. Now, what becomes tough is trying to represent to the court an impartial view of what is before you versus being a good advocate for your client. And that's where I think that you can hopefully be able to do both. But my takeaway, and I guess the initial comments that I'd like to share are at the onset, procedurally, what rules are you about to follow? If you're with a judge that has more familiarity with patent cases, then the local district court probably has patent rules, and they might have operated within them quite frequently. And they like them or they don't like them, or they have common changes that they make to them. So I would understand the background of the judge in the previous patent case decisions or intellectual property case decisions that they've had. Have they been consistent? Have they followed a certain set of rules? And if your judge does not have any patent case decisions that you can find, then I would probably talk about that at the onset with the court and say, well, the district court rules are X. We would like to track that, or we would not like to track that for a variety of reasons. And those rules have not been utilized in a number of years, and comparable to other districts, they might not be a little bit dated, perhaps, or there might be procedural reasons where, as an advocate for your client, you might want to advocate for something different, or just for the sake of streamlining litigation, there might be good reason to honestly represent to a judge, look, if we track different rules, and this is something that we've been able to work through in my chambers, I think with quite a bit of success, which I'm happy to talk about in more detail, but following a set of rules that are different than the Court of Federal Claims rules in order to bring claim construction to the first step in the proceeding. So even before discovery opens, going through full claim construction briefing, and then a preliminary constructions with the parties before a Markman hearing and a Markman order, has resulted in great success to create settlement early on, has also minimized discovery issues, and has also pushed forward with early motions to dismiss on perhaps one-on-one issues, or quicker motions for summary judgment. So that's just a way of an example of understanding the procedure in order to utilize that, and then educating the court on the unique nature of patent procedural rules. With respect to substantive patent law understanding, and the nuances of patentability, and all of those things, again, I think it depends in large part on your judge, or, as was noted extensively in the morning panel with Judge Stark and Judge Braden, understanding the law clerks. So knowing who the judge's law clerks are, knowing what their timing is within chambers, what their background is, even their technology background, might be a huge benefit in order to understand the degree of advocacy that you might have to make. And with that, I will hand things over to Ulysses, and happy to answer any questions on those comments or provide more.
Thank you for those comments. Can everyone hear me okay? Mm-hmm. I'm going to take a step back and as opposed to more of the sort of procedural or granular sort of aspects of helping a judge, helping a trial judge, helping a jury understand patent law. I'm going to talk about what I think of as sort of something that connects human beings, something that connects with everyone, regardless of their expertise, their subject matter. And this is coming from me, having been in different fields. I'd say being able to construct and being able to really depict a story. And I'm even being in academia, being at the bench and research, it took me by surprise, because whether it was the PI or the principal investigator or other graduate students who were ahead of me per se, they were saying, okay, so we can write a good story. And you're like, wait a minute, it's not a story. This is what we found. This is what we didn't find. These were the facts. This is the data. But it was still how you necessarily presented it that, controlled whether what you, showed to your reader, whether it got published or not. So I think the same thing, even in terms of patent law, because we're talking about the, sort of legal aspects of patentable subject matter. That's, kind of black and white. Novelty, I guess we could argue, that's kind of black and white. But when you start talking about obviousness, which is where the proverbial rubber hits the road for patent law, I think that story and how you, convey that story to your audience is really what matters. So I think having worked at technology companies, I'll talk about my experience at W.L. Gore or my experience at Paul Corporation. The founding, sort of vision for that company, the technology of that company, it still to this very day resonates and sticks with me because of those underlying stories. In the example of W.L. Gore, he was working at DuPont and wanted to pursue further research on this compound PTFE. Well, his higher ups at DuPont didn't want him focusing on PTFE. So he left, started his own company, and part of the ethos of that company was that the associates got to work on things that they wanted to work on because of the inherent value in it. And he literally went and shopped this PTFE wherever he went. If he went skiing, if he went to the beach, he would ask people there if they could use something or do something with this piece of PTFE that he carried around. Same thing when I think about the story for Paul Corporation, and that's David Paul. He got the Congressional Medal of Honor for his filtration and separation, compounds and devices. But the sort of underlying aspect of that, he was working in the Manhattan Project, and it was everyone was sort of separated. And whatever he was sort of presenting, this exact filtration device for filtering this component of uranium, it didn't necessarily get accepted, didn't end up being used in the Manhattan Project. Well, he went and took that and tried to filter any and everything that he could sort of that could be filtered. And to this day, this company is alive and well and filtering across whether it's oil and gas, whether it's filtering in medical devices, whatever it is. That story, I think, is really what helps everyone kind of understand where they started and where they ended up and where they're going kind of in the future. So if I could just take a step back and just say at a 50,000 foot view of just really conveying how important story is, and particularly for a judge, regardless of whether they're an expert in patent law or not. Everyone really resonates with the story.
Yeah, Judge Holte, I mean, you don't necessarily need the story to tell or understand the invention, but does it help you follow the case better, or do you see with some of your colleagues who may not be as may not have the technical background or the knowledge of the patent system as much as you, that these types of stories and narratives are really important for them?
Yeah, most certainly, especially understanding the history of the technology background as it pertains to patents that are currently in suit. Oftentimes, with the example stories that you just gave, correct me, but I'm a mechanical engineer, so PFE is Gore-Tex. Okay, all right.
Yeah. By the way, here we go, an example.
Yeah. Well, so that's a great example of understanding law clerk background. If I have a highly technical case that relates to technology that is electrical or computer related, one of my interns with an electrical engineering degree is here. We rely on them for computer code translation and certainly for other technical aspects of things. And but the story of Gore-Tex, I think, seems simple now, and we all take it for granted when we go skiing or buy it on a budget website or something. But back in the time that it was invented and first being utilized was a phenomenal improvement. And that story, I think, is very important to understand in the history of patentability, and especially when patents in suit in 2024 are patents that have perhaps even expired at this point, but the lawsuit relates back to the 1980s or the 1990s. Recalling that, I think, as part of the procedure is something that is important to do as a judge, especially when considering aspects of things like obviousness.
So I don't know, Ulysses, if you want to expand on that, or
if you just repeat the question, please. I was lost.
No. If you just wanted to expand, if you had anything to expand on.
Yeah, and I think even I'm thinking back. I'm looking at Professor Mtima here and thinking back even to my law school class. And this is me sort of doubling down on what I'd already sort of said. It kind of later on I learned he had a theater background, an acting background, and kind of everything just sort of made sense in terms of the way he really conveyed some of these some of these legal sort of subject areas based on story. And I really, if I said this, in fact I am going to say it. It was yo, I got that blow, which helped me understand going back to sales. And I literally just can't, when you really construe things through that narrative, I really feel like it just helps, sort of people understand regardless of the sort of technical aspects of it.
Yeah. Let's see. All right. So I just want to make sure if anyone had any questions. I was serious. If you have a question or something occurs to you, please just raise your hand. And same with online. Just go ahead and post the question at any point in time. So one of the things that I often talk about when I teach patent law is, it's a unique area of law. It's often, patent lawyers often view themselves as separated off from the rest of the body of American jurisprudence more generally. in part because patent law cases and the doctrines themselves have developed uniquely and oftentimes without contact with other areas of American law, but also because patent law combines two areas, two professional areas, kind of science and technology and law. And one of the characteristics shared between those is love of detail and love of technical details in particular. How important have you found it to be to always step back at times and think about the fact that, yes, we're talking about novelty, we're talking about how to construe the patent in the claim in the Markman hearing, but how important is it sometimes for the lawyers to perhaps remind the judges, this isn't unique to patent law, right? We're asking you to do something that you would do in a contract dispute case, you would do in interpreting a title deed or a statute. Yes, I mean, the terms are different and specific concerns are different, but the broader legal principles of which we're talking about here and the type of jurisprudence and policies that we're asking you to apply are not unique.
That's a good question. You want to start with this one?
Well, yeah. So I think it's human nature, perhaps, or it's human lawyer nature, to try to apply what you do know to what you don't know in order to create a comparison. And certainly for patents, folks seem to understand titles and survey lines of titles and how claims are describing the survey lines. And I think probably utilizing your patent law teaching notes as a background, that's where we started. Although, side note on stories, Professor Mossoff has a number of Star Wars jokes and Star Wars comparisons that infiltrate his patent law notes. And I heard conversation at lunch with Ulysses and Professor Mossoff about Star Wars, and there's nothing that I don't know anything about more than Star Wars. But when I would say certain things that were in these silly patent law teaching notes, my students would resonate with them. So perhaps even if you don't understand the story, you should utilize the comparison. One day, I promise I'll read a Star Wars book or something. But I think to some extent that results in a bit of a handicap because you're oversimplifying or you're trying to explain something. And the best example that I can give as a judge now is my court. For folks who don't know, we have jurisdiction in a nutshell over all monetary claims against the U.S. government with nationwide jurisdiction. And what that means, in short, is it's an all civil court. There's no juries. So to the extent that we have a trial, it's just a bench trial. And the usual jurisdiction of the court covers about 30% or so government contracts cases, 30% or so takings cases, including intellectual property takings, which would be patent infringement by the government in some way. And then kind of a 30% random smattering of Native American treaty disputes or vaccine injury appeals or tax refund cases. So when I came to the bench, I had clerked on the court, but of that smattering of cases, tax cases was not something that I had any experience with. And not too much experience in litigating government contracts cases. It turns out the government contracts cases, I would say comparable to patent law cases, are based on the federal acquisition, the FAR, which is essentially the giant statute of rules that govern federal acquisitions, kind of similar to the MPEP for patent lawyers, thousands of pages of nuanced rules that cover things that you have to have experience with. And it was easy for me to try to have things tried to explain to me in overlap. But the reality is that government contracts and federal acquisitions is somewhat its own thing. And federal tax law, if you don't have experience with it, it's its own thing. And when trying to communicate with lawyers about things, different than patent cases is, I think, the expectation that I would appreciate for lawyers is not necessarily a comparison to what they think I do know, but perhaps just a background and a primer in where we're at. And what the history of something is. So when it comes to some nuance of tax law, probably stepping back and understanding that we're dealing with federal tax credits that were associated with a certain act, and that the main reason that Congress passed the act and the main purpose for it was X, and everybody can agree on that. You get both sides to agree on it. And then you kind of piecemeal off there, and then you very neutrally explain where the differences are. In understanding. So now, and perhaps tax law or acquisitions law is just so unique that you can't compare it to patent law or property law or other things that I had more familiarity with. But my suggestion in trying to explain things and then trying to break things down for a judge is really just to kind of step back. And Professor Matima probably does a great job with explaining that. And when you're dealing with a very nuanced specialty line of advocacy, as patent law is, having the ability to just break it down and communicate with your mom about it is a great trait. Because if mom doesn't track what you're saying, then a judge that doesn't have that level of understanding, certainly not a jury, is going to have that level of understanding. So the advice that I was given by the judges who I clerked for, and that I was told in practice, is make sure that you can explain it to your non-lawyer mom before we get into the courtroom, because if not, you're going to just waste everyone's time.
Yeah, to pick up on that, I'm as you were talking, I was sitting and thinking about how I try to help someone understand a complex topic for something they may not, for an area they may not be familiar with. And one thing, as I said before, which is the reason why patent lawyers exist, I think, is because of the obviousness law. When we talk about obviousness, I think about how I explain it to inventors and in past places of work. For example, at Paul Corporation, and my analogy was always Mr. Potato Head. That if you took this lip and put it on the Mr. Potato Head, this mismatching eye, and this mismatching hat, and then say, here's your invention, which is what I felt like, a lot of the times some of the examiners would sort of be presenting to us as, hey, that's your invention. And the argument obviously was to sort of take that apart and say, okay, well, it wouldn't be obvious to take this pair of lips and put it with this ear because that's this and there's that. And our inventors would say, oh, so then it would sort of click off in their head. And then the next thing that they would sort of go into is trying to argue why, or get the technical teeth behind why this pair of eyes doesn't go with this hat or doesn't go with this ear. Now, these days, I'm not sure what the potato head situation is. I heard it's changed, but when I was a kid, it was fairly simple and straightforward. And I didn't mean that as a dig at all. I literally don't know.
Building something in Minecraft, maybe.
Yeah, something. I got to update it now. Everyone's getting younger. I'm getting older. We have a question, Adam.
Oh, excellent. Yes.
So I'm a law student, haven't started practice yet, but I'm wondering, especially to you, Honorable Holte, how are some of the ways you've seen practitioners sort of weave these explanations into their arguments? So if you're doing like an oral argument, you have limited time, so you don't want to get away from the meat of your argument while you want to be able to explain to the judge. So are there ways that you've seen people do this very efficiently?
Yeah. So
did everyone hear her question? I just want to make sure, and if they could hear online, or should I repeat it just to be sure? Okay, great. Awesome.
Okay. Yeah.
Sorry.
So I think Ulysses has done a great job of articulating this, and perhaps because it's his great education at Howard University Law School, which it sounds like you have as well then, as a current law student. Congratulations. So I think having a story to tell with a metaphor, and Mr. Potato Head is a phenomenal example.
I think everybody here can do obviousness now.
Yeah.
No, nothing.
And that's directly explaining a complex aspect of patent law to non-lawyers, right? So that's a really good example. The one thing that I might add to that is doing it with a slide. So in my hearings, especially when we're dealing with a complex aspect of law and we're having a lengthy oral argument on it, whether it be a tax case or whatever, I think every courtroom now has very good electronic visual aids because of kind of federal mandates in order to incorporate those. Having attorneys utilize slides that are really good, and here's a tip for young law students in the room or junior attorneys, is if you can be the person on the team that can put together really good slides and do it quickly, that's a phenomenal value where you can also probably end up in the courtroom, in order to assist with that. And the beauty of putting together slides is probably more of an art form in not having too much, but having just enough, having it be neutral, but also advocating in your neutrality in order to highlight the points of the law that are probably most favorable to your client. And if there was a class, a non-law class that they should teach in law schools now, I think it's like slides, how to put together a well broken down slide, and also utilizing slides, I think, for legal aspects of things. So slides don't necessarily have to be for pictures in order to look at figures for claim construction or something. But if you had slides that piece together parts of the law and the precedent that, especially in patent law, where you're talking about complex nuances of patentability related to obviousness, there's not going to be any precedential federal circuit case that deals with your exact same technology. If there was, the case probably never would have gone and never would have been filed. We would have just all looked at that case, or it would have not been patentable because there was already a case that described the tech 20 years ago, so it was inherently not patentable. But if you're looking at precedent for, say, obviousness, and you can have slides that quickly and briefly explain the technology of whatever those prior cases are as they relate to what your particular technology case is, I think that's a great aspect for the court to help understand and remind what the precedent is as it relates to the current problem that's before them.
Good question.
Yeah.
Oh, we have another question, Adam.
Yeah, excellent.
Hi, my name is Ariane. I'm also a student at Howard. I have a question related regarding what you guys already mentioned. What was the most challenging case that you faced? And what is the reason why? And what was the process that you used to come up with the decision, the final decision on that?
I'm going to let Ulysses take this one. I just want to say, though, that you can tell how great students are and how smart they are by the quality of their questions, and you guys are knocking it out of the park.
Yeah, I can't really think of a case. I'm not a litigator, but it wouldn't be directly related, and it might be proprietary at this point thinking about it. But I think in terms of handling or addressing anything difficult or anything that you're unfamiliar with and or uncomfortable with is really starting in what you already do know and arguing and building it from there. Meaning, so if you're looking to distinguish some nuance aspect of your technology, and now I'm thinking of it coming to mind with arguing with, say, patent examiners or writing an appeal brief to the USPTO, to the PTAB. It's, I guess, knowing your subject matter through and through, how you got there, and let me think how to say this, and delineating or distinguishing what's already there. So if they're saying this is your invention and it's obvious because you would have put this with this, with this, with this. Well, I'm saying, well, no, let's apply, for example, where we talk about, I guess, gram factors or some other factors in which we're basically going around obviousness or distinguishing obviousness. And we're saying, well, based on this, what happened in this instance, where there was serendipity and the place blew up, and then I come back in, the smoke clears, and here's my invention. I mean, really looking just distinguished. I can't overemphasize enough, like the really being able to tell a compelling story and really being able to get into your listeners' head, to something they can relate to, something they find humor in, something they'll walk away with 10 years later, 5 years later, still able to really conceptualize what you said, and it being in your favor, and you obviously construing that in your favor. I'm not sure if I answered that question directly or not, given that, my experience might not be as, as focused in terms of ruling on a case, but that's kind of like where I go to.
Yeah, so following up on that, and I agree with exactly what you're saying, and also getting back to the slides. So there's two cases that come to mind, both highly technical. Both of them were not patent cases, though. So the first one, and these have both been decided and are long gone off my docket, provided my circuit colleague from this morning doesn't return it to me, perhaps, is that it was a government contracts case related to wireless router encryption technology. So, and I don't know how many high-level math geniuses there are in the room, but when you look at the encryption requirements of routers, they get into complex integers, which is not something that I had cared to remember years after law school. But the question essentially became one of whether or not the standards that had to be met for the procurement were of a certain type of encryption, and then whether or not the awardee was able to satisfy that level of encryption. So, and it was a problem in my chambers also, because it was the government contracts law clerk with an English degree who really liked government contracts, having to engage with my, I think, chemical engineer at the time, who wanted to do nothing but patent cases, and then they had to work together, but they were able to pull it off. But the reality was, and I can still think of the slides and the level of detail that was put into it, where we looked at the requirements of the standards and the specific words of what had to be met, and they were graphed up, overlapping. And the question was whether or not A equals A from one to the other, and then whether or not those equal what the offeror needed. And that's really what the case boiled down to after a couple hundred pages worth of briefing and, a lot of money. And the answer was yes, and no error on the part of the government. But it was clear to me that as part of the advocacy, muddling the issues and trying to confuse things was perhaps a strategy. And in order to break through that, I think that it was good advocacy on the other side, and in that case, on the part of DOJ and intervener counsel, in order to get through it. The other example case was a pure legal issue on a case where the facts of the case are somewhat inconsequential, but it was a very confusing aspect of law that looked like the law as it related to another procurement was different than what it was. And it seemed like the language of it was different. But if you looked at the appellate history of the case that led to the precedent that was problematic, and then you looked at previous decades-old precedent, it was obvious that the law was one way over another. So in short, while it seemed like a claim was correct at the onset, there was one slide in particular, I remember, that broke it into 4 different squares of how the precedent fit together, and then the next slide was like color coded, and it was green and red, and I remember it just really made sense. And at the end of the day, when pressed on it, the plaintiff in that case couldn't deny that the slide was correct, and the slide was essentially a bit of a solution to understanding some murky precedent in order to come to a correct outcome.
These are really great points, and they're, you hear them constantly circling around the exact same things that you've heard in all of your other law classes, right? The analogical reasoning.
The first case that you discussed, was that a bid protest?
Correct.
Oh, okay.
Yeah, you weren't on it.
No. That was the case where the protester said that that they wanted to offer that standard, but the government said they couldn't meet it. Is that what happened?
No, it was that the offeror or the awardee, whether or not they met the standard in order to be properly awarded.
Oh.
So what you're hearing is, right, analogical reasoning, right? In fact, Judge Holte did that when he said, far, and he realized his audience. You guys haven't probably taken an advanced class in government contracting. So he said, like the MPEP, right? And then if we had another audience, you'd have to have another analogy for what the MPEP is. But, and, you know, the Mr. Potato Head as well, you know, it's the metaphors and the use of visuals, right? Which, by the way, is long-standing. I always love to tell this story when I teach the U.S. v. Adams case, which we all read or study in patent law. You know, the companion case with Graham v. John Deere in 1966. Where the invention is incredibly complex, right? You know, wet activated battery that you had a crowded field of prior art, and it's really complex for people who don't know the art. And so students have a hard time breaking through it. And I love to tell them the story actually from the actual oral argument, Supreme Court, yeah, where the lawyer representing Adams activated the battery and it was connected to a light bulb. At the start of his argument. And so the light bulb lit up and he left it on in the entire argument. And in fact, one of the justices was overheard saying to another justice as they were leaving the Supreme Court courtroom, a couple hours later, the damn thing is still on, right? He won his case for his client. So, you know, which is the pre-PowerPoint version of the PowerPoint, right? That this, you know, making it very real, concrete, understandable, but also not committing the other vice of making it too simplified, too oversimplistic. So, and you're kind of navigating the trade-off of making it accessible through visuals, graphs, slides, and the story, the narrative, and the metaphors, but then not oversimplifying to the point where you open yourself up to a legitimate attack from opposing counsel, or you end up, you know, misrepresenting or accidentally misrepresenting or misleading on the law itself. Yeah.
I'm going.
Yeah, Professor Mattia.
I mean, I was a litigator, and so, you know, we tend to think that in explaining your position, coherence oftentimes leads to cogency, right? Jury, they're like, if I can follow that, then I believe you, right? And if I can't follow the other guy, I don't believe him, okay? Now, the reality, of course, is that that doesn't necessarily mean that the first guy is in fact telling the truth, right? So what I wonder about is that juries obviously can be misled that way, but judges really can't be, right? Okay, so does the coherence leading to cogency, does that play any role? Does it have any effect on the judge's perspective, not of the underlying substance, but for example, with respect to the perception of the credibility of each of the advocates?
Yeah, I guess it's probably to me. Yeah, so absolutely. And I was just in the Western District of Texas doing an event a couple of weeks ago and observed a patent jury trial and the attorneys that were advocating there. And it was the method for success there and the way that you communicate is very different than what's going to be a benefit in the Court of Federal Claims. Because you're dealing with a judge who has had the case from the beginning, who has understood the procedural posture of where everything's going, and you can't create a new narrative before a jury at a trial. And that's one reason I think in large part why Court of Federal Claims cases are so rarely going to trial, is that it at the point where and there's an actual factual dispute that could decide something, which is rare in and of itself, you probably already know where the judge is going to go on that particular factual dispute based on the previous rulings that you've had related to summary judgment at a minimum. And there's probably enough clarity where a settlement could have been reached. Is that for the most part, I think, I don't know what the statistics are. I've tried to look these up, but the vast majority of the very rare trials that we do have are strictly related to damages, which is in and of itself kind of a new issue that doesn't come up until you end up at a damages phase or something. So in short answer to your question, though, I think the creation of a narrative to explain a story is not something that I guess is primary compared to where the legal precedent is as it relates to the uniqueness of your facts. And what's more important is being able to tell a story and have a narrative, as Ulysses described, with respect to explaining the facts. And especially if it's a patent case or a very complex government contracts case that deals with the technical nature of things, having just a clear, straightforward narrative to explain those facts.
No. Yeah, Ulysses, what's your we heard from Judge Holte, the explain it to your mom. Do you have a similar type of story or something related, and where you have to try to convey to someone, this is what the level at which you need to be able to explain it in order to make your case to a judge or to some type of official?
I think I'd go back to what you were saying in terms of striking a balance. But and this might just be how I've evolved as a practitioner, in that I'm usually unconcerned about the level of sophistication. I think everyone can sort of they see your background, see it, like you said earlier, look on the internet, look you up, know that you're serious and that you're not here to kind of fool around. And I'm thinking about how I explain or convey inventorship when it was kind of at issue with an adversary. And I tell this story about when I was a kid and I grew up in Philadelphia. I remember being in the park and I remember seeing dog excrement, and I remember telling my parents, like, hey, like you should put a contraption around the dog's rear end and it would catch the excrement. And everyone sort of laughed at me. All my parents, and to this very day, laughed at me. Oh, that's ridiculous, so on and so forth. Well, later on, we found out, it was discovered that there was an inventor who had put together this exact contraption and was like a multi-millionaire. And my parents were like, either A, you were bound to be a patent lawyer, and B, we should have never laughed at you. But wait a minute, to go back to the inventorship concept, which is what I bring in, is that I actually had not invented anything. All I had was the idea, whereas this person had an actual harness that attached to the receptacle and was able to detach and sort of reattach the receptacle that was, sort of harnessed. So while I had an idea, I didn't have conception. I didn't have anything more, but there was nothing more there which would have taken it from an idea to an invention. Now everybody laughed, and that story's going to stick with people. But the concept for what an inventor is the person that has that idea, has the sort of contraption or conception to take it beyond just merely a pie in the sky idea for something that actually, could work to some minimal standard. So I really, and that just might be my, how I've evolved as a practitioner, that I stick with the story. It's almost the sillier the better.
Because the silly story will stay.
It will. So everyone here is an expert in inventorship and obviousness.
You've certainly forever changed I'm going to use the Mr. Potato Head.
Okay.
I'll cite you.
Okay, please do. I'm going to look for it.
I have a question for you, Ulysses. So I'm sure part of your job and from your excellent in-house experience is advocating and explaining patent law to corporate people,
which is even harder.
Yeah, well, I want to know about that. So you've done it at a couple of companies now. What can you share on that?
That's an interesting question. I'll talk about my past experiences. And I really think for corporate types, it's putting it in, well, two things. And I'll say this for the students in terms of you practicing, period, and something I had to come to understand as an attorney. because I'm thinking that, you know, we're so smart and we know the answers and we're telling you. And it's like, no. They can and will do whatever they want to do, no matter how smart you are, and that you speak their language and you speak your language, which is the law. And they still may do something else. And that's sort of something you have to come, you know, to maybe come to Jesus moment with yourself. But to answer that question succinctly, it's putting it in terms of what's at stake for what you're kind of giving away for free to the public. And by not capturing what I'm telling you, you should capture in terms of what this invention is, you putting a sort of fence around this idea or this concept and putting it to them in that terms, like, okay, whatever I'm telling you, here's the fence for all these sort of words and bits and languages. And you're saying, well, I don't want to do that. And you're leaving out this part of, let's just say we're sticking with the analogy, you're leaving out this part of the land. Well, that part of the land, you're donating it to the public for them to use as the starting point for their invention and or for the basis. Well, I guess it'd be prior arguably, but still, it would give somebody else an area to start to, you know, to an area, a point of origin or a point to work to begin their invention, just because you didn't see fit to sort of put the gate around it. So I think it's putting things in terms of what you're losing or donating or giving away, particularly if there's a lot of, you know, the investment in R&D, that you put all this money into this research and development, and you're giving away half of it because of whatever reason you want to be. You put things like that to corporate sites, they get it.
You know, that was such an effective description that it made me think of a story that now I can use in class. That, okay, you are going to get a great big, because it's now legal, blunt of marijuana, and you're going to smoke this thing, okay? But think about the fact that, you know, so what kind of room do you want to build for people to put? And the corporate guy is saying, well, that type of room is good enough.
Yeah. And
you're saying, okay, but you do realize that some people can get a contact high.
Yeah, exactly.
Right? So all the smoke that you're letting get out.
Exactly. That's even better.
Give away your goods.
But it was the way you just described it, that made me think of that. Okay. So clearly what you did was effective.
Yeah. Thank you. Yeah.
Now we're all going to go home and light up.
Take that to Bentonville.
Yeah, exactly.
Well, as the person teaches property, I also enjoyed your use of the analogy of land.
Yeah, and the
the fences, exactly. So that's and showing that this isn't any different from other ways in which we acquire property, deserve property, and are trying to use property.
Demarcate.
Yeah. Sorry, Judge Holte.
Well, no, I have a question for you now, Adam. I still want to make sure we had time for it. So you do a lot of communicating and explaining to legislative bodies or agencies.
Yeah.
What goes into that, and especially how do you explain the baseline of patent law in order to get to the point of where advocacy is?
So that's a really good question. It's almost like you really know these issues and know how to ask good questions. So what Judge Holt's referring to is I file a lot of agency comments. It isn't just the USPTO that adopts rules that relate to patents. So the FDA does, NIST does, National Institute for Standards and Technology, who are because that's the agency that's in charge of the Bayh-Dole Act for those who may know about that piece of legislation, and other agencies as well, the FTC. And in following with Judge Holt's opening remarks about knowing your audience, so like how I explain things in the comment that I'm filing to Director Vidal, USPTO, I'm just going to jump right in and start referring to, you know, using patent law concepts and doctrines and just terminology, because I know that if she's reading it, or if one of the people at the USPTO is reading it, they know this. I don't do that with the FTC or NIST or even the FDA, because they don't know patent law and they don't necessarily even know what goes into inventions. So I spend more time actually describing the equivalent of the act of the stories and the act of invention. I also spend actually a lot of time on the front end just essentially describing a little bit of the history of the patent system and actually explaining, I now have kind of a stock section, the proven success of the U.S. patent system as a driver of the U.S. innovation economy, that I now just kind of insert at the beginning, because that's what I say is supposed to be the framework or the foundation, because a lot of people don't understand that, because everyone has heard the rhetoric and the policy debates. They've heard patent troll, they've heard the patent system's broken, they've heard of all the crazy patents, the patent on a dog toy that's shaped like a stick, or the patent on how to use a method of operating a tree swing and things of this sort. And so they don't necessarily know actually the underlying research and the history and the economics. And so I set that out. Again, kind of trying to establish for the audience, recognizing that they don't necessarily know these things and they should know them, because that's the framework for understanding the more particular regulatory rules that they're considering. For instance, if I'm making the point that this imposes more costs on innovators and inventors, it makes it harder for people like Ulysses and your clients and at Walmart to get patents. Well, that has to be a cost that is balanced against the benefits that we do get from these people from having patents. And they won't know half of that side of the equation if they are only talking about the cost and not the benefit. I've testified before Congress, is also what Judge Holte's referring to, and most recently did so for the U.S. Senate on the proposed bill for restoring patent eligibility doctrine, the Patent Eligibility Restoration Act. And talking to senators and congresspersons is at even a lower level than talking to people at the FDA. It's not true of Senator Coons and Senator Tillis, who actually understand these issues incredibly well, and they've spent a lot of time on these issues. But other senators and congresspersons, this is not something they spend a lot of time on. They do a lot of issues as legislators, and so you definitely have to tell more the story and the narrative and talk about Samuel Morse, the inventor of the telegraph, or Alexander Graham Bell, the inventor of the telephone, kind of key into what they know and their stories that they learned growing up as examples that they can kind of rest on for relating to this more complex issue and doctrine that we're talking about in the legislation. But it's a great question, because it goes again in a circle, and it kind of bookends nicely this discussion as we're coming to the end, because we just got the few-minute warning about how, knowing your audience, knowing the context of knowledge of your audience. And so you can have a judge like Judge Holte, who knows a lot about patent law and has lived patent law, and even Judge Alsop and others, and judges who are just as knowledgeable. Or you could have Senator Tillis or Senator Coons, or you could have other people who don't know as much, and you need to make sure you're always pitching at the level of which your audience can understand it. And I think what Ulysses said too about building out the story is incredibly important, making it real. So this is not just some sort of abstract issue of doctrine. But I don't want to conclude. We still have a minute or two. I want to make sure that the distinguished panelists have a chance to say something. So we'll start with Ulysses.
Yeah, and this one, I've been involved with this, I think, since I've been in law school, ever since I graduated law school. And I think I always try to leave, the students with a little tidbit, a nugget of advice. And I'd say, two things, for the students. Number one, I cannot overemphasize the importance of mentorship, and that mentorship is a relationship like any other relationship in which you develop, you have to nourish, you have to maintain. Obviously, it's not different than other ones, but it still has those aspects, those components to it. All of my mentors, and at each level you go to, some become more important, some less, but you still have your mentors there. And I try to get my mentors coffee or whatever have you, when I was in law school, whatever I can kind of at my disposal. And I'm really encouraging students to think about that from that standpoint. The second thing, and I heard a lot in the other panel, the Hustle and the JP Morgan panel, and I really just wanted to overemphasize this, is that be lawyers of how can we do this, and yes, as opposed to no. I can't tell you how many relationships that I've developed, at professional relationships from the patent attorney standpoint, by simply approaching clients as how can we do this? How can we figure this out? As opposed to no, you can't do that. Instant credibility, like instant, permanent, forever credibility with your clients when you sort of take that tact.
Judge Holte?
Yeah, no, I agree with both those points, and especially on the mentorship, is that this conference, perhaps better than any other for young law students, is such a wonderful opportunity to connect with people. This firm and environment is also wonderful for that as well. So take advantage of it, keep in touch with people, and 20 years later, then you'll have a seat at one of these ends, and I look forward to hearing from you.
So, well, thank you, everyone. Thank you for the great questions. They're fantastic. And thank you especially to Judge Holte and to Ulysses for fantastic insights on how to convey patent law to other people who may not know as much about it.